Hello students, the topic that we are going to discuss today is the rules regarding the Employees Compensation Act 1923. This is a part of your subject, the Industrial Law, which is the code BBAN 505. Now, in the previous video, we had discussed about what the Employees Compensation Act is, what are the objectives of the Act, the scope and coverage of the Act, and the various definitions under the Act. In this video, we are going to talk about the various rules regarding the Workmen Compensation Act. What are the situations under which an employer is liable to pay compensation, and what are the situations under which a worker is not liable to pay compensation. So firstly, we will talk about the situation under which an employer is liable to pay compensation. So as per the Act, we know that if a worker gets any kind of personal injury, that means that injury could be because of an accident and which may also result in death of the employee also. So, but then what is necessary is that this injury should take place at the place of employment, or it should take place in the course of the employment. So what do we understand? In the place of employment, we understand that the person is in the factory premises, some accident took place and the worker got injured. But what is the course of employment? Course of employment means that if a person, say, I leave home in the morning at 9 a.m. to reach the factory premises at say 9:30 or maybe 10 a.m., right? So while going towards that office, that period would also be counted as course of employment. Also, if in case there are two factories in the vicinity and there is a transfer of worker which may be taking place, the supervisor may ask the employee or the worker to go and report in the nearby factory. So if a person is going from one factory to the other and in the meanwhile he meets with an accident, then that accident would be again during the course of employment. So the worker would be again liable to get compensation because of any injury which happened because of a road accident. But during that time, that employee was on duty because he was completing his shift, and at the same time he was asked by the supervisor to report from one factory premises to the other factory premises. So this is the first condition, that is the personal injury should be there under which the employer is liable to pay compensation. The second situation is the occupational diseases. Again, these occupational diseases should be an outcome of the nature of employment, or they should be during the course of employment that a worker may have contracted any disease. Say for example, people who are working in the hospitals, or the people who are working in the medical research and development laboratories. So such employees are exposed to a lot of harmful viruses, bacteria, and so many other radioactive material and such things. So during the course of the employment, if a worker contracts any disease, so that disease would be an outcome of his nature of employment. And if you remember, I also discussed in my last video that example related to the cold storage. So there also it was an outcome of the nature of employment because of constant fluctuation in the temperature. The worker got unwell and he had to be hospitalized or he had to be given treatment, and thereby he lost his earning capacity for that particular duration. So any injury which is taking place by accident within the meaning of this particular act, so compensation has to be paid to the employee. And it is also necessary that whether it is an occupational disease or not, this has to be certified by a medical practitioner. So for the purpose of this act, there are a lot of medical practitioners are appointed by the state governments and who are going to examine the employees, and then they are going to certify that this kind of disease is an outcome of the nature of employment. The other thing could be, we can take another example into consideration. There may be places where a lot of water-based activities are there, maybe washing of say vegetables or washing of grains or some kind of stuff. So as a result, wherever there is water, and if some water logging is taking place and mosquitoes are breeding there, so because of the breeding of those mosquitoes like dengue or chikungunya mosquitoes, they may bite the employees, and the employees might get dengue or chikungunya. So this is because of the nature of employment that people are engaged in. The other things are, lung related diseases. Wherever people are working in cement industry, so they are exposed to a lot of dust and those kind of stuff. So this dust accumulates into the lungs of the people, thereby causing lung infection and other diseases, and even lung cancer for that matter. So under these situations, the employees are to be paid compensation by the employer. Now this is a classic example. This was a case and the employee had filed a suit in the court. So this is Indian News Chronicle versus Mrs. Lazarus. This case took place in 1951, and here in this case the employee was into consideration. That person was an electrician in the press, and as a part of his duty he was required to go from heating room to cooling room quite frequently. So while going from one place to another, he suddenly fell ill and he was attacked by pneumonia. So because of this, there was no bodily injury, but then the person lost his capacity to work, and it was also a kind of a personal injury, and therefore the compensation was paid to this particular employee. Now we are going to discuss about the conditions under which the employer is not liable for compensation. So the first case is in respect of any injury which does not result in any disablement, be it total or partial, for a period exceeding 3 days. That means after 3 days the worker was fit and fine. So within 3 days, that is okay, a person was not able to report to work. But if the injury is not exceeding 3 days, in that case the employer is not liable for compensation. Now in any injury which is not resulting in death or the permanent total disablement caused by an accident due to various other reasons. First thing is that the worker was under the influence of alcohol or under the influence of any kind of drug. So if the worker was under the influence of alcohol, in that case he is not liable for compensation, because obviously when a person is intoxicated, he loses control over his body and he loses control over his mind, and as a result accidents might take place. The second situation would be the willful disobedience. That means the worker is not obeying the rules and regulation, he is not using the safety gear which is being provided to him, and in spite of various caution words written near the machines, he is still not obeying them, and he is doing all the things which is against that particular nature of employment. So in that case obviously accidents will happen, there might be injury, and in such situation if it is proved that it was willful disobedience, in that case the employee would not be paid compensation. So these are the various situations. Now the employee, if he has contracted any disease which is not related to the nature of employment, or which is not caused by accident or the occupation, in that case also the worker would not be given any kind of compensation. Say for example, a person is working in a silica mine, right? So, and if he gets any other disease, say for example tuberculosis, so the two are not related to each other. He can get silicosis and those kind of disease because of extra exposure to silica and all, but he cannot get tuberculosis. So these two diseases are not related to each other. So under these situations also compensation would not be paid. Also, till the time the employee has filed any suit in a particular labor court or somewhere, until the time the judgment is not given by the court, till that duration the compensation will not be paid by the employer. So the employer would wait for the judgment to come by, and then only he is going to pay the compensation amount. The next topic that we are going to discuss is the doctrine of notional extension. So this means that a worker in the course of his employment does not connote only the actual work, but any other engagement which a person would have to undergo as a outcome of his job which may be beyond his work hours also, and which may be beyond his workplace also. So let us understand it with the help of an example. For example, a worker was working, say, in a factory in Ghaziabad, and the owners do have a factory at some other place in Gujarat, right? Say example, Surat. So the worker may be asked to, because of the need, he's a skilled workman, so he may be asked to go and work in that particular factory. So if he's going from Ghaziabad to Surat, if something happens in between, say for example, he falls off the train, injures his feet, or fractures his any leg or maybe a hand, in that case that would be counted as a notional extension, and as per the doctrine of notional extension, he would be liable for compensation. Then the important factors which are covered under this act, under section 4, is the amount of compensation. So amount of compensation is really important. So in case of partial disablement or total disablement, what would be the amount of compensation that would be paid to the employee? So firstly, it would depend on the nature of injury which is caused to the employee, and secondly, it would depend on the monthly wages of the employee that was last drawn by the employee. So a person may be working for say 20 years, he may have started work at a monthly wage of say 1500 rupees, but as on date he may be getting 15,000 rupees. So the current wages, that is 15,000 rupees, would be taken into consideration for calculating the compensation amount. Then apart from this, there is a relevant factor which has been given in the Schedule 4 of the Act. So relevant factor is a number. So we will understand it with the help of an example again. There is a worker who is say 27 or 20 years of age. He dies in an accident which happened in the factory premises. So should he be getting more compensation? And the second case is an employee who was say 53 years of age, and he dies in an accident during the course of his employment. So the compensation for a young worker would be much higher in comparison to the compensation for an older employee. The reason being, the younger person had a complete life to earn that much money, whereas the older worker who was 53 years of age, he has earned all his life, and if we go by the retirement age, so only 6-7 years of more earning was left on his part. So that is why a young life lost is more damaging for any family member, and obviously there are a lot of people who were dependent on the income of that particular employee. So that is why the relevant factor is higher for younger people and it is lower for older people. And also there is no distinction that is made between an adult worker or a minor worker when we are taking the compensation amount, or when we are calculating the compensation amount. The same level or the percentage of compensation would be given. Compensation has to be paid when it is due, and there is penalty for default also. So as per this section, compensation has to be paid as and when it is due. It is the liability of the employer to pay the compensation amount after proper calculation and all. If in case he is not paying the compensation amount on time, in that case a penalty would be imposed, and there would be an interest at the rate of 12% per year on that particular amount, which he will have to pay. Alright, so that's it in today's topic. Thank you so much and happy learning.
Thank you, ma'am.